You have a house, cars, retirements, pensions, bank accounts, and you're afraid you're going to lose it all because of a divorce. It's not necessarily the case. Let me educate you on what happens with assets and debts during the divorce process. The first thing we have to do with assets and debts, for that matter, is we have to determine its characterization. Now, what does that mean? There's two types of assets or debts in California. It's either a separate property asset or it's a community property asset. Now, a community property asset is essentially anything that's acquired from the time you get married to the time you separate, irrespective of whose name that asset or that debt is in. So by way of example, if you have a home that you purchased during the marriage, even if it's only in one spouse's name, it's going to be determined that it's a community property asset, absent of very minimal circumstances. Same thing goes with anything else, with vehicles, bank accounts, pensions, any money that you invest into bank accounts or retirement. If it's during the marriage, it's going to be deemed to be a community property asset. Now, there's some very minimal examples where it may not necessarily be. By way of example, if it's a gift or an inheritance, then it remains a separate property asset, even if it's during the marriage. However, absent some very minimal circumstances, it's very likely that whatever you acquired is going to belong to the community and therefore would be divisible 50-50 at the time of divorce. Now, one spouse may have a claim as to why they should get more than half of that asset, and it may be a very good claim under the law. However, absent some of these circumstances, these assets will be divisible half and half. So don't be too scared. You're not going to lose everything that you have to your significant other, to your husband or your wife. The law provides for a fair distribution of any assets and debts that are acquired during the marriage. The same concept applies with debts. If you have credit card debt that's in your name alone, doesn't mean that you're solely responsible for it at the time of the divorce. If it's a debt or credit card that was incurred during the marriage, both parties are going to be liable for it half and half, irrespective of whose name it's in as well. If you like this video or found this information useful, don't forget to watch our next video, and also please like, subscribe, and share.